the European, with the two branches, and the European Convention on Human Rights and the Charter of Fundamental Rights of European Union. And we have the African system, which is the last chronologically speaking. The nature of all these texts is international law, but the use of these is limited to specific geographical zones and can't be cross-used, let's say, by inhabitants of living in other places, meaning the Europeans have to use the European system and the American system, and so on. And above that, we have the universal level, which is the highest, and it concerns at least 193 UN states and even more. So my first hypothesis of the causes of the defeat of institutionalizing an international model of protection of human rights is the incapacity to overcome the quarrel, the conflicts between Universalist conception, from which human rights were drawn from, and the so-called relativist one. There also I would like to tell you what are these two, very briefly, what are these two positions. The universality spread in the 18th century with the movement of enlightenment, les Lumières, is based on the idea that every human being, whenever he or she lives and where,
Marine, you're muted. We can't hear you.
Oh no, so from the beginning you're not hearing me?
Well, the beginning,
the last minute.
It was yeah.
So did you, now I don't know where to, did you hear the Universalist conception or no?
Yeah. It was just for the last few seconds.
Okay. So this conception is influenced by Christian conception, Christian religion, sorry, which consider that every human being has rights, as the same as others, by the way, just because he or she is a person. Why? Because each person being at God's image is sacred. The result of that is that a state doesn't create the rights, but recognizes them. So it can't eliminate them. The theme of universality of human rights is important. It seems very theoretical, and especially to students, I imagine, but it's very important in the relationship between Western societies and what we could call them Oriental ones, or between North and South, if we want. But this conception, Universalist conception, is not accepted everywhere. The opposition is known as relativism. So the relativists consider that the recognition of human rights has to be different according to the time, the place, the culture where they are recognized. Their main characteristic is to dispute the universality of the rights over three fronts. We have three different categories, and states would choose between them. The first contesting emanates from countries which consider that it falls to every state, in the name of its sovereignty, to define and to guarantee human rights, such as it conceived them. So the principle of sovereignty does not have to give up in front of the principle of universality of human rights. So first group is sovereignty, the criteria. The second is based on the pretension of a right for every people. So now it's a collective right to assert and defend its cultural specificity. It recalls the people's right to self-determination, to fight against colonialism and discrimination. For example, we have Asian countries that pretend they have Asian values, different from Western values, such as, I give some examples, superiority of the family and the society onto an individual, the respect for hierarchies, or the importance of harmony, religious and racial harmony, trust in authority, or preference given to the consensus onto the conflict. Also, the African text mention taking, for example, the Charter, the African Charter mentioned taking into consideration the virtues of their historical tradition and the values of African civilization, supposedly different from Western or even Asian traditions and culture and values. This is the second front, so cultural specificities. The third front, against universality, takes its source in the religious conception of the society, which is defended by states within the Organization of Islamic Cooperation. It's a group which includes about 60 states today. According to this conception, human rights have to be interpreted in the eyes of the religious law, and the universality of human rights couldn't serve as a pretext to compromise the principles and the rules of Islamic Sharia. So in case of conflicts, the Sharia should prevail. Roughly, the mutual criticism between these two groups is, on one side, those who consider the universal conception of human rights being an alibi for Western cultural imperialism, also called neo-imperialism, and those on the other front who see in the invocation of the cultural diversity a pretext to refuse to respect the fundamental rights of the human being. So that is my first hypothesis of the failure of having a universal system of protection of human rights. The second hypothesis of the causes is the weakness, what I call the weakness of international law. It's a law based mostly on will of the state. How do we know that? Because the international law is mostly based on conventions that the state decide freely to ratify or not. Indeed, there is an exception to that convention law. It is called the jus cogens, composed of imperative norms, which are binding even independently of state express consent. What is the ratification? The express consent is the ratification of the convention. Here, it would be independently of the state express consent. And this jus cogens was recognized in the Vienna Convention of the Law of Treaties, 1969. So, if a treaty conflicts with a peremptory norm of general international law, it is void. In a way, in few words, the sanction is the nullity. It would be null. The problem remains to determine the content of that new category of rules, these jus cogens. Its identification seems to be more complicated than the determination of the customary law, which is already complicated. In fact, for the moment, only genocide, slavery, war of aggression is recognized as jus cogens, which is very few among these, all the human rights we know. Second thing that I would like to mention in the introduction is about birth of the recognition of rights. It is pertinent to remember that the protection of human rights happened first at a national level, before being protected at an international level. I will take only some examples that you know, and some you don't know, probably. The famous Magna Carta, we are in the 13th century, 1215, when the feudal barons, the nobles, forced the tyrannical English king John, which nickname is John Lackland, to agree on a charter. And by the way, was also supported by the church leaders in order to limit the king's power. And that Magna Carta stated that the king must follow the law and could not simply rule as he wished. It was the first document to state that citizens, in this case the English people, had such rights. So it's one of the most ancient texts we have. Another very ancient text, and less famous, and always in the 13th century, sorry, it's the Mandan Charter. It is named after the territory situated over the Niger River between the present-day Guinea and Mali. It was proclaimed by the founder of Mandingo Empire and his wise men. The charter contains a preamble and chapters about recognition of rights, for example, right to education, food security, but also prohibition like abolition of slavery by razzia, freedom of expression already, so much discussed in France for the moment, and already recognized in the 13th century, and trade. From 2009, it is inscribed in the representative list of intangible cultural heritage of the humanity of UNESCO. So these are, and then you know perfectly the very well-known English Bill of Rights, 1689, or American Bill of Rights, 1791, or the French Declaration of Right of Man and Citizen, 1789. So first, the recognition of rights was started at a national level. Another element to take into account, third one, is the crisis source of evolution. Most of the time, it is thanks to the answer to the most violent crises of history that human rights manage little by little to become binding. For example, in France, the Declaration of Human Rights, 1789, is born during a huge revolution, chaotic and very violent period. So it's just to give you a little hope in this difficult period. It could end in a positive thing. We never know. Also, at an international scale, it's the same. The horrors committed during the First World War led to find a solution to create peace. The League of Nations was created, was founded. It was an intergovernmental organization as a result of Paris Peace Conference that ended the First World War. The League of Nations was the first permanent international organization. Its goal, as stated in its covenant, was to maintain peace, including preventing wars through collective security and disarmament, and settling international disputes through negotiation and arbitration, very fashionable nowadays. At its greatest extent, from 1934 to 1935, it had 58 members, but it didn't work well because how do we know that? Because we had the Second World War, with much more horrifying actions committed by a lot of different sources, and Japan, fascist Italy, Nazi Germany, and so on. So, but at least the positive aspect of all these horrors is that this massive violation of human rights arouse strong reactions from the international community, translating a will to learn from this terrible experience. So we can start now the study of what is existing now. Even if it's very few, this is why the title of the conference is Embryo only, because it's not as important and as sophisticated and well organized as regional system, the universal level. But we have some things, and we will see what is existing. So now you have only the structure under your eyes, and so it's section 1, international text. The very first text is the Charter of the United Nations, which is the continuation of the League of Nations that failed. Let's say that we try to renew with a new institution this idea of collective solution to our general problems. So the Charter of the United Nations was signed in 1945 in San Francisco, as a conclusion of the conference. And the Statute of the International Court of Justice is part of that charter. We come to the International Court later on. If we look at the text, the preamble of the charter mentions, immediately after the will to avoid to return to the war, the faith of the authors in fundamental human rights, in the dignity and worth of the human person, in equal rights of men and women, and so on. I skipped the rest. This is the only aspect that concerns human rights. And we have also the first article of the Charter dedicates this approach by placing in the heart of the missions conferred to the United Nations, that is, developing, promoting, and encouraging respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. So few things, very few things, but it's the start. If the Charter of the United Nations is an international treaty, it codifies nevertheless several principles of the general international law. It contains also another important article, which is Article 103, a clause by virtue of which the obligations imposed by the Charter win in case of conflict with other conventional obligations of member states of the UN. For example, the European Convention on Human Rights. So if the European Convention on Human Rights is in conflict with the Charter of the UN, the Charter should prevail. And the European Court would admit that, would recognize that superiority. It's the case Berami and Saramati. It was easier to follow with the PowerPoint, but it's far, you have to skip all this and go further. Berami and Saramati case law. We are in 2007. That it considered the Charter such as interpreted by International Court of Justice. So it's a way to accept the supremacy of, thank you very much, perfect. It's a way to accept the supremacy of International Court of Justice. The European Court emphasizes the fact that the European Convention should not be interpreted in a way that the control of the court should cover actions and omissions of the contracting parties covered by the resolution of Security Council. The result would be what? Because making such a control would be analyzed in an intervention in the fulfillment of an essential mission of the UN. So the court is recognizing the hierarchy of the institution. The universal level is above the regional level. In doing that, the European Court establishes the autonomy of the UN system. Consequently, it considers that the contracting parties to the European Convention are not responsible for the actions of the UN. A major progress in the activity of the United Nations in human rights field was constituted by the writing of that very famous Universal Declaration of Human Rights, adopted in Paris by the United Nations General Assembly at the instigation of famous, in France at least, René Casablanca only, I know, on December the 10th, 1948. By the way, this is the date that Amnesty International has chosen for celebrating the fight against violation of human rights with candles. So let's tell you some words about this Universal Declaration. It's the second paragraph. So this declaration is an act deprived of compulsory character. This is what is a problem, a weakness of it. Contrary to classic international treaties binding for states. Of course, binding for the ones who have ratified or adhere to this convention. So it doesn't enter into legal heritage of the individual. It means that an individual cannot exploit it successfully in front of the national court. But it's still a very important text because it will be an example it will be used by a lot of regional system and revolutions afterwards. So we can see the importance of that text in Article 1 that you have now under your eyes. All human beings are born free and equal to dignity and right. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Or reading that, we can see that head of states still have to read and reread and reread the Universal Declaration. Anyway, that should remind you something, this text, especially to French students, and they should remember Article 1 of the French Declaration, very similar. I hope they did that in their mind. By the way, it is easy to understand that this text is the expression of a universal vision of law that I mentioned at the beginning of the conference. It is about a consecration of inalienable moral rights and inherent to every human being. In other words, one has simply these rights because is human. Okay. This faith in dignity, equality of all humans, as well as in the other essential principle, which establish the base of human rights, are met in the great part of cultures and civilizations and religions or philosophical traditions. Let's say, at least in theory, because we mentioned before Asiatic values or African values that are different. Nevertheless, the declaration preserves a huge symbolic declaratory strength. First, because it is the first text at an international level to recognize rights, even if it's not binding. It's a source of inspiration to each regional system of protection that I mentioned, American, European, both Europeans and African. We still are waiting for ASEAN system. We have the ASEAN, but it's not really a system of protection of human rights. And it's the fundamental principle of that declaration acquired over the years values of customary standards, making of this text a standard of common reference to all the countries. It is considered the base of international protection of human rights. Okay, so this is the very base. We mentioned already the Charter of the UN, the Universal Declaration. Because the declaration is not binding, the General Assembly asked the Commission of Human Rights, replaced from that time by the Council of Human Rights in 2006, to prepare a project of covenant in order to translate these moral rights into legal rights, okay? Because it was not binding, so the idea was now the international community is ready to respect binding rights, and so it's time to have another text to make them concrete and binding. So the aim was to elaborate a legally binding text to complete and to strengthen the declaration, which had only a simple declarative value. This text was supposed to recognize all the human rights, so both economic, civil, political, economic, civil, political, social, and cultural rights, as well as equality of women and men for the enjoyment of all these rights. But there was a profound conflicts between states, reflecting the ideological debates of that time. Let's say we have roughly two groups. The first group is the capitalist states, advanced right of liberties, what we call first generation of rights. I will show you the generation in a minute. And the communist states insisted on the economic, social, and cultural rights. What is the second generation of rights? So if you look at the next slide, you have to be at least. You will see the three generation of rights corresponding to three different periods and three different demands to the state. So we have the first generation, individual rights, universal rights given to the essence of the human being. So we don't consider blind to differences, universalist conception, okay? I give you some examples. We have the French Declaration of Human Rights, European Convention, and ICCPR. We will talk about it in a minute, International Covenant on Civil, Political, and Rights. Then we have the second generation. So, no, in the first generation, I should mention that what is asked to the state is not to do an interference, to let people to freely use their freedom and rights. Second generation, rights given to a situated person, a mother, a retired, an ill person, so with different need. So it is asked to the state more actions, positive obligations, if you want, in the European vocabulary. Here we have the second covenant, International Covenant on Economic, Social, and Cultural Rights. There will be a third generation with collective rights, mostly around the environment, the right to live in peace in same place or beautiful landscape. Okay, so that was just a remind for you for different generations. So this ideological conflict between capitalist countries and communist ones forced the General Assembly to ask to the Commission in 1951 to write two different covenants instead of one. Okay, the two I just mentioned, one is on civil and political rights, and the second on economic, social, and cultural rights. Why two? Because of conflicts, but in that way, the state could freely choose to ratify one, the other one, or both. It was a compromise to let more freedom to the states. So now the third paragraph, which is international covenants. 2 words about these international covenants. We are in 1966. Okay? So it took a long time between the Universal Declaration till these covenants. 18 years were necessary to reach an agreement. Now, just to give you an idea, we mentioned that UN has 193 recognized states, 193. So when you see 171, for example, here, for the economic, social, and cultural rights, it's out of 193, okay? And the civil political rights, it's 173 states. Someone has a dog. That is barking. You should turn off your microphone. Okay, thank you. So it's always out of 193, okay? So we could see that two states refused to to ratify the Covenant on Economical, Social, and Cultural Rights. You can go. I'm doing a little bit of teasing. You can go and see which one of these states refused, and all the others, because it's 193 that could ratify these covenants. So these covenants, which came to specify the content of the rights expressed in the Universal Declaration, are of real treaties and thus have strength of law for the countries which have ratified them. It's binding law, okay? In spite of the remaining of profound discord, the covenant are adopted in 1966, but 10 more years of expectation are necessary to come into effect. The duality of these instruments adopted within the United Nations system does not have to be interpreted as establishing a hierarchy of these rights. Okay, there's not. It is not that the civil rights are more important than the economical and social rights. There's no hierarchy at all. It's just because of ideology problems, political problems, and by the way, the Cold War specifically didn't help. Now we have to jump to the juridical strengths to the covenants. Some articles are what we call self-executing. Self-executing mean that they are directly applicable. Which are they? The provisions of the text that are clear enough. Okay, they are clear enough and precise enough to receive application without necessity of adoption of a particular legislative or statutory measures of execution by a state. No translation, let's say. Okay, so they are called self-executing. But this condition is not filled in for the provisions program of the International Covenant of 1966, in particular in business, social, cultural laws. So these are an indication, a guideline for the legislators more than something else. The content of the covenant. These covenants, by the way, consist in what we call sometimes the International Charter of Human Rights. When you hear International Charter of Human Rights, it's not the UN Charter, pay attention, it's the whole Universal Declaration and covenants, both three fundamental texts of protection. They have common provisions, by the way, these two covenants, preambles and some rights. We have no time to see them, but let's just mention the right to self-determination of people and gender equality. You can find these two rights in both covenants. Okay, you see, you know what are I suppose the civil and political rights. I can give you some examples. The ban of torture, cruel and inhuman degraded treatment, ban of slavery, equality in front of the court, liberty of thought, consciousness, right to vote. All are civil and political. Economic, social, right for the work, sufficient standard of living, good health, education, things like this. Okay, there's also elements about children in both covenants to confirm that they have rights. Then it was already protected by the Universal Declaration of Human Rights and the Declaration of Geneva of 1924 and the Declaration of Rights of 1959. and then there will be the specific Convention on Right of Children in 1989. So before the adoption of these international covenants, these rights were recognized by declaration. Okay. What we need to make sure that these texts are effective, we need a mechanism of control. So the third element, you can skip that and go to the third. Yes, because I mentioned, I forgot to tell you that we should move. Number 3, thanks for the help, by the way. A mechanism of control. So who will control? You know, it's very important to control and to sanction if in case of violation. So both covenant establish supervisory bodies called the committees to watch the respect for their implementation by member states. So we have 2 committees. The first committee is the Committee of Human Rights. It's for ICCPR. ICCPR, remember, it's the International Covenant on Civil and Political Rights. Okay. By the way, both are 18 independent experts checking the implementation of the article of the covenant by member state. The committee received communication formulated by member states on the violation, presumed violation, of the covenant by other member states. First possibility. So it's between states. Okay, one state is accusing the other not respecting the covenant. And we have a first optional protocol taken in, or let's say, coming into effect in 1976, which allows the seizure of the committee through communication, that is the word, by individuals. So this is the second possibility, individuals that are victims of presumed violation. And third possibility, finally, the committee can also formulate general observations, which allow to clarify the meaning of the articles and give advice to the states on the implementation of the covenant. This is more before the laws. Okay, these are the 3 possibilities, 3 competence. There's also a second optional protocol to this covenant, ICCPR, aiming to the abolition of death penalty. Very disputed subject, you know, in the world. But we have to mention that these the countries are permitted to make a reservation, allowing the use of death penalty for most serious crimes of military nature committed during the wartime. And we have to mention now the second committee, the Committee of Economic, Social and Cultural Rights. This committee was not created by the International Covenant on Economic, Social and Cultural Rights, but later on by another institution, the United Nations Economic and Social Council, so-called ECOSOC. It's just a resolution creating it in 1985. So this ECOSOC, which is competent to control its implementation. But as it was already submerged by it had too numerous of activity, too big, it decided to create a committee as a supervisory body to control the implementation of the covenant. Also 18 independent experts making general observation on periodic reports, also competent to examine state communication. But, there is a but, it is not allowed to address injunctions to the state. Only reports offering proposition of solution. But if the state doesn't want to follow this a report, it is free to not respect it, not take it into account. And the most for individual rights aspects is the individual communications. The General Assembly has adopted an optional protocol conferring to it this competence. So through another protocol adopted in 2008, that this individual communication can be addressed to this committee. Make sure to understand that these both committees are in charge of checking the right application of the covenants, but they are not jurisdictions. Okay, they are not jurisdictions. Oh yes, I didn't mention, you have it on here on the slide, that is entered into force in 2013, which is late. Okay, so these two committees are not jurisdiction. They are simple organs. They could be used in the future as jurisdiction, but for the moment, it's not the case yet. In order to complete the covenants, that are general examples of specific, we have general examples of specific international conventions. And so I gave you some examples, but we have hundreds of them. So a huge number of them. I put it here like elimination of all form of racial discrimination, discrimination against women, or right of the child that I mentioned, the convention that I mentioned before, 1989. But we have, again, hundreds of conventions that is completing these, the Universal Declaration, both covenants of 1966. Now we have to deal with, in a second section, with international judicial control this time. So the recourse to international judge, ICJ, International Court of Justice, is exceptional for state and extremely limited for private individuals. So we'll study it, but we know that it's extremely limited for individuals. Further to major conflicts, which marks the 20th century, international jurisdiction were born. We can classify them in three categories. Okay, in international jurisdiction, we have at universal level, we have the regional systems, but we will not study them today. So first, the jurisdiction with general vocation. Some international jurisdiction have a general purpose, such as the International Court of Justice and the International Criminal Court. So first, the International Court of Justice, which goal is to settle disputes between states, okay? Between states and only between states. So if you have a problem with a state, you will not, this is not the right court to go in front of. The establishment of an International Court of Justice is a culmination of a long-term evolution of methods for the peaceful settlement of international disputes, the origin of which dates back to very ancient times. Let's do a little bit of history together. I hope you like history. Historically, mediation and arbitration preceded judicial settlement. Also because traditional societies, so-called holistic societies, from the ancient Greek holistic, conceived the settlement of disputes much more in discussion. Palabre would say African system. I don't know how to say that in English, but discussion or wise and ancient persons giving advices or trying to dissolve the conflicts. It's more ancient than the judicial intervention. Okay, and still it's difficult. Let's say it's not natural in Asia and Africa. So the first was known to ancient India and Islam, and the mediation and arbitration. As for arbitration, there are many examples in ancient Greece, in China also, and also among tribes of Arabia. In the customary law of European ports also of the Middle Ages, and also in the practice of the popes. So it was very largely used and in different perspective and practiced by different systems. So the Council of that was just a cultural preamble, which is, I hope, pleasant for you. The Council of the League of Nations was tasked to prepare a draft Permanent Court of International Justice, CPGI, draft Permanent Court of International Justice, called not only to hear and determine any disputes of an international nature submitted by the parties to it, but also to give advisory opinion on any dispute or matter referred to it by the Council or the Assembly of the Company. Okay, so Permanent Court of International Justice was asked to work on by the Council of the League of Nations. And so we assist to the birth of that Permanent Court of International Justice. So it is the predecessor of what you know now, which is the International Court of Justice. It held its inaugural sitting in 1922 and was dissolved in 1946, so it's not a very long duration. The work of this PCIG, the first permanent international tribunal with general jurisdiction, made possible the clarification of a number of aspects of international law and contributed to its development, even if it was a short period of time. Remember that international law is recent, very recent, compared to our national ancient law. Between 1922 and 1940, this permanent court dealt with 29 contentious cases, very few if we compare to nowadays work of international judges. So only contentious cases between states, and delivered 27 advisory opinions. Its activity was stopped by the Second World War, and so it was dissolved in April 1946. So that is the mother, let's say, of the International Court of Justice. So coming now to the International Court of Justice, it was established in 1945 by the Charter of the United Nations, same year of the Charter of the United Nations. This court is the main judicial body of the United Nations. It is located in The Hague. It is composed of 15 judges, which is very few if you imagine that it has to deal with all the conflicts between states, and we know that we have a lot of conflicts between states. We could see that every day, especially with Trump America, probably. We should ask to Melania. It is composed of 15 judges elected by the UN General Assembly and the Security Council for a renewal term of 9 years. And also, we can mention that English and French are the official languages, but it's a detail. So, this court has two functions. To settle, that is a picture, just to show you how beautiful it is. Okay, so it settles legal disputes between states. This is the litigation function. Okay, this is the first function, litigation, to decide who is right and wrong between states' conflicts. And second, gives advice on legal issues submitted to it by UN bodies this time, or other institutions. This is the advisory function, okay? Advisory function. Under no circumstances can it settle a dispute between individuals, okay? So this is not the judge of individual disputes, conflicts. Only UN member states, those that have acceded to the statute, for example, the statute of the ICG. The statute of the ICG is annexed to the UN Charter on the creation of the ICG. Okay, so first, the state has to be member of the UN. Second, it has to have acceded to the status of the ICG. Or those that have accepted its jurisdiction under a certain condition can make a seizure of the International Court of Justice. And this is, I have to add a little comment here, and this is a weakness of that system. It means that if a state disagree with the idea of a control by the international judge, it's easy. It just has to refuse the competence of the jurisdiction, and there's no way to, unless, of course, let's say informal pressure, but it's not law, to make sure that state would stop to violate another state's right, because the court is competent only if one state has accepted its jurisdiction. If we compare to a citizen, it's very strange. It would be like I can have a trial only if I have accepted the idea that a judge would solve my conflicts. I do that comparison just in order for you to understand how weak is that solution. So we need, why I mentioned before, just to connect to the introduction, the weakness of international law. Why it is weak? Because it is a law very much based on the consent, the will of the state. If the state is democratic and very and is ready to accept control, there's no problem. But in other cases, it's complicated. So this just a little technical thing. The consent can be expressed in different ways: by an agreement called a compromise, by a treaty, or a convention providing competence to the court to which the state that is a party, or by a declaration. The disputes submitted to the ICG are varied. For example, I give you some examples: border activities, delimitation of land and maritime borders. You know that borders are always very source of conflicts. Or jurisdictional immunity of a state, military activities, armed action, diplomatic relations, air incident. These are just examples to have an idea, more concrete idea of what the ICG is doing. Its decision, called judgments, are binding on states, but only on states that have consented to the jurisdiction. I mentioned it yesterday. And unfortunately, we have only 66 states out of 193 that have accepted this compulsory jurisdiction of the International Court of Justice. So very few. However, if the decision is not complied with, the UN Security Council may take measures to ensure that the state concerned complied with the decision. But as you probably know, it's very heavy mechanism. Then we have the second jurisdiction, international permanent jurisdiction, is the International Criminal Court, more recent. This, on the contrary of the previous one, is judging people for the gravest crimes, not detail, not small crimes, but gravest crime, the more important. The members of the United Nations have recognized that it is duty for each state to protect its population against what? Genocides, war crimes, ethnic cleansing, crime against humanity, genocides, war crimes, ethnic cleansing, and crime against humanity. But the international community, within the framework of the UN, has the secondary responsibility to ensure protection against these four crimes. So first, the state will intervene, and then, in a second time, subsidiary intervention is the international community. So this International Criminal Court, ICC, was created by the Rome Statute, which is a treaty adopted in 1998 by 120 countries. It is the first international criminal court that sits permanently. Nevertheless, the ICC, as such, has only existed since 2002, which is more or less recent. And has a lot of problems, by the way. Indeed, it was on that day that Rome Statute entered into force, which required prior ratification of the statute, and not only the adoption by 60 states. So that was long to obtain, 60 states to ratify the statute. It is also in The Hague, and you have no picture. But unlike the ICG, does not belong to the United Nations system. It is composed of 18 judges in 3 chambers, and also a prosecutor. We very often hear about this prosecutor. It is in charge of investigations and prosecutions and a registry. One of the specificities of the ICC, it is complementary with national criminal courts. We mentioned it before. You have the criminal court, national ones interfering first, and then we have the international criminal court. So it means that the ICC does not intervene if a procedure has not been implemented in good faith at a national level. It's a international principle of law, the exhaustion of national remedies, always. Moreover, its competence is governed by this Rome Statute. We mentioned it already. So it has jurisdiction only over those who have committed the most serious crimes. We mentioned already. State, therefore, are excluded this time. So we have one judge for the state, one judge for the people. It's easy to remember. Its competence is also limited in time and space. First, it can only judge crimes listed above, we mentioned, committed after the entry into force of the Rome Statute, which is only 2002. And what about what was before? There's no solution through that judge. And finally, it may judge only crimes committed in the territory of a state party to the statute or committed by national of the state party. It may also be a state that is not a party to the statute, but has accepted jurisdiction of the ICC. However, jurisdiction does not need to be accepted when the UN Security Council brings the case before the ICC. So there is an exception when the UN Security Council brings the case before the ICC. The case may also be brought by a state party or investigated on the initiative of the prosecutor we mentioned before. Throughout the proceedings, the accused has rights, hopefully. If the person is convicted of one of the above-mentioned crimes, the ICC may impose a term of imprisonment and a fine against a person and order forfeitures. Victims of crimes have a right to reparation. In any case, the question whether the rules of jurisdiction of ICC are really of such a nature as to ensure its full effectiveness arises. It is also known that the ICC's area of jurisdiction is directly related to the maintenance of international peace and security. We also have to be complete to mention International Criminal Court ad hoc, which is a second category. So they are jurisdiction of United Nations or established by a treaty, which were created to judge international crimes, war crimes, genocide, crimes against humanity. But in a precise conflict, not in general, in a precise conflict, and have authority to judge during a determined period that fact which are connected to it. So 1 day before, no, and 1 kilometer after the zone, no. Okay, we have two international courts of that kind. We have the International Criminal Court for Ex-Yugoslavia and International Criminal Court for Rwanda, the genocide, and in Ex-Yugoslavia, the war. But we have to rush a bit if we want to finish and let you time for the questions. And we have also a third category, the internationalized court, also called mixed or hybrid courts. They are special courts. They sit in the state where the crimes were committed. Okay, they go on the territory. They include national and international judges, both, and they apply both national and international law. Okay, this is why they're called mixed or hybrid. Half, a little bit of national and international judges, a little bit of national and international law. We have the Special Tribunal for Sierra Leone and the High Iraq, Criminal Court to judge Saddam Hussein and the senior officials of the Baas Party, which was the Saddam Hussein's party, Baas Party. We also have the extraordinary chambers within Cambodian courts. In fact, in 1997, the government asked for the help of the United Nations to set up a trial to bring to justice the top leaders Khmer Rouge. In 2001, the Cambodian National Assembly adopted a law carrying creation of a court for the pursuit of the crimes committed during the period of the democratic Kampuchea, so on 1975 and 1979. And finally, we have the Special Court of Lebanon. We hear a lot about Lebanon these days, so Special Court for the Lebanon to judge the attack committed in Beirut February 2005 against the Lebanese former Prime Minister Rafik Hariri. There was a special court for the attack on this former Prime Minister. We also have the International Court of the Sea, important nowadays because of the pollution of the sea, established by the Convention of the United Nations on Maritime Law. And we are in 1982 and come into effect in 1994. And finally, the Special Tribunal, we mentioned it. So we also have, but we will not have the time to deal with that, some other form of institutional resolution of the disputes, in particular in economic litigation. So we'll not do a long conclusion. I will just say that in theory, human rights at a universal level could be correctly protected or are correctly protected. But there is a huge lack of political will to accept the idea of being submitted to a judicial control, and also a lack of finances. International organization or international judges or and jurisdictions are need to have finances, to have money to exist, and the states have to give money to be judged and to be controlled. And so theoretically speaking, I would say it's not bad. But as for the practical protection, there's still a lot of things to do. And if we compare to regional system that I mentioned at the beginning, inter-American, European, at least African is still struggling also with financial problems and political will also. But if we compare to this regional system, there's no doubt that the universal level is less effective than it is in the regional system. But it is also through to be the lawyer of that system that it's a new one. It's a very recent law. This is why I mention to you the national protection texts of protection in the 13th century in different continents in order for you to compare how ancient is the protection of human rights, and still we have a lot of problems in our old democracy to respect the rights, and especially perhaps in France, we have recent law that are not particularly defending the rights, not even the academic rights, the university in particular, but anyway, or journalists or whatever. And so for a recent system, it's more difficult. I will stop there and listen to, I don't know if you have questions. I'm sorry not to show my face, but I don't know how to do that, so I will not do anything that would worse the situation. Thanks for the help, the technical help that
You're very welcome. Thank you very much for the lecture. I'm sorry for distracting, for have distracted you maybe by not.
No. For the students, I don't know, but I think it was easier. I don't know. They would tell you, but
We did what we could.
Right, thank you very much, Marine. It was a pleasure. A very comprehensive lecture again. Very, very profound overview about the system, and quite rightly you described it as an embryo. I mean, is there any chance that the embryo will finally be a child or a human being? I don't know.
I'm not sure.
Oh, well. Well, in any event, are there any questions? I think we should start with the students.
Yes.
Are there any questions?
They are in charge, by the way, during they are in charge of making that little baby born beautiful adult. We count on you. Oh, they're still there, by the way.
Don't see anyone. No questions in the chat either. So no one wants to ask a question. Oh.
You had so many questions, Frédéric.
Oh, I've got a lot, but
or they were more interested in yours, or it was less clear. No, it's a joke. Or I don't know. It was a little bit difficult, by the way.
It is absolutely, because it's with such a lot of information. I would like to ask you a question. I see the point. I mean, I get the impression that it becomes more and more difficult nowadays to finally come to terms with human rights and to find a common ground of discussion. If you haven't got a common ground even in some countries when it comes to basic values. I mean, we've seen that in Europe, we've seen that in several European countries, that we've got severe problems with basically certain groups that are not really sharing the same values as the majority is. And is there any realistic chance to sort of come back to the situation we had in the 1960s, perhaps in 1940s, 50s, to find at least a way to discuss questions of human rights protection without them being used for basically purposes of power politics. I mean, if you can't even talk about human rights to a country because that country is using this sort of shield, we are not going to talk about human rights because there are some sort of Western imperialistic attempt to our sovereignty, then basically can sort of give it up entirely if they just don't want to talk about it. Is there any realistic way to go back to at least try to find a common ground? Because at least we've got the texts and the countries. Well, some of them are, but most countries are not really distancing themselves from those texts, and those texts are there. I mean, the conventions of the 60s and the covenants.
Are you? Do you mean in the whole world, or in Europe specifically? In the whole
Europe,
world?
I think Europe is difficult. It becomes more and more difficult, but I think there's still some sort of way to discuss those issues between the countries. I mean, societies themselves have some problems, which, however, are not really a question of international law, but in the world, from the global point of view.
I have an original way of thinking that question. I do a lot of comparison. I like to compare states and people, because I see a lot of common reactions, and that is one aspect. And it's quite strange, because when we manage to solve problems, head of governments had a huge ego too. I mean, if we let's talk about our General de Gaulle. We just mentioned it recently. He has a very huge ego. It's not that he was a discreet person and not keen on power, but still, behind all these problems, so nothing new. I mean, in that perspective, but it seemed that there was behind these head of states more preoccupation of the common interest that it seems to lack nowadays in these different actions we can see. There's still a lot of ego. That is something that was already the case, so it's nothing new. So that is not the problem. And I don't know why, but it's also, we can see that in the civil society, let's say, not the states, but in our institutions, there's a lack of concentration or focusing on what is very important for the common interest, for the whole society. What should be done to a common good, common development. perhaps also, which is not the case at the global level. It is the case in Europe. I think our generations, and probably it's worse for the students, we have forgotten what war means. We have a lot of wars. But France is having a war in Mali, for example. But it's very far. It's something not real, not very concrete. But it's not that can be an explanation for Europe, but it's not an explanation for the international, for the global world, because there are a lot of wars. But what impressed me when we studied the history of the European Union is that we were able one day to say, okay, what happened, who win one day and have lost one day. We will not continue that hate, culture of hate and revenge, and so we have to stop and say, now we restart. We don't forget, but we restart new. Now it seems that it's more difficult. Most of the time, very often I compare for my students the situation between France and Germany at that time, and between Israel and Palestine now. It was very much difficult for both sides, the idea of working together, governing together, creating a new world together. Why was it possible at that time, and why it's not possible now? It's still a very big question for me. I don't see any specific reason, because Palestinians are suffering so much, but also Israeli, and even if they are stronger, but still everybody is suffering from a long time, and except a psychological explanation, if I compare with people that like to suffer and continue to suffer, even if when the situations should be ended. I think it's more or less the same for the states. We continue to apply politics that we know that are not solving the unemployment, for example, the poverty, and we continue to use it, or we continue to take a resolution at the UN level, and then we don't apply it, and we don't know how to make sure this would be applied. And I think one of the most difficult aspect of international law is the lack of sanction. There's not enough sanction. And again, I compare with citizens very often, saying when a baby born arrives in one of our countries, we don't ask him if he wants to apply this law or another law, even if then growing, the person is considering that this law is unfair. But if it's unfair, then you have to do a democratic way of voting for a person that has a more common idea with you. In international sphere, the only thing that we can use in the end is war, economic war, kind of very unmoral pressure, or real weapons war. It seems that we are very still prehistorical conception. It seems that it's difficult to move on from this perspective to something more neocortex, using part of the brain. So I have no idea why we don't manage to find because we have a lot of intelligent persons in the world, and so why we don't manage to find a solution to that question of sanctions, and finally, it's a very wide world. Will the stronger ends to impose his law, which is not allowed to citizens in a country, is allowed in the international sphere. So it's for me, it's very pathetic and very strange why we can't find another solution than wars, because in the end, this is the only solution, is to have a war. I don't know if that.
Yeah. I think the problem is quite there. It's I sometimes, well, I don't know. Normally, you could try to, as you mentioned it, you could try to find a solution that appeals to the common benefit, like, for example, common economic benefit. Even with human rights protection, you could try to at least link the two elements together and show as an example that when you've got decent human rights protection, then the economy and the people's lives in general will become better. I mean, the European example is not such a bad example after all. However, it sort of fades a little bit. It looks as if the European Union is not being regarded as a model anymore in that respect. Too many people are taking it for granted, perhaps. Perhaps other problems are more in the are more visible than the achievements. I don't know why that's the case, but that's probably a question for someone from outside the European Union. The thing which I'm wondering about is we do have some standards at the moment, even though they are not particularly effective. You can't really enforce them. Now, is there any sort of danger for those standards to be altered in a way? I mean, are there any countries that sort of would like to get rid of those treaties, rid of those standards altogether in order to renegotiate human rights protection from the very beginning? Is there any such thing on the international sphere? Because some of those, we have to admit that some of those treaties have been concluded at a time where, well, the world was much simpler than it is nowadays, and, well, some countries just didn't have a say, which might have been a good thing for the development of human rights, because in that way you were able to finally come to a conclusion, to find a compromise solution. The more states you've got, the more difficult it gets. Is there any such thing as a backlash, or?
It's interesting to know that the relativist countries that I mentioned, perhaps a little too quick at the beginning. I was worried about the being late, but the relativist countries, so-called the relativist countries, they, according to the idea that they don't share the same values as the others, let's say the Western countries, they should not, they should renounce if their country have already ratified the convention, or they should not ratify the conventions or withdraw from it, because the first thing I should say is the international text of protection of human rights are full of Western conception, Christianism, philosophy, all these aspects are really Western. There's no doubt on this. And in this, it's perhaps pretentious from countries, colonialist, ex-colonialist countries, to pretend that this is universalist. It's true that is part of the world. But what is also true is when we see, for example, the Tunisian revolution, what they were asking for were exactly the same rights as we have in French text, for example, freedom of expression, freedom of consciousness, freedom. And so it seems that even if it's full of Western conception, it could also be common to other parts of the world. Not everything, but it could be common. what these relativist countries are doing usually, they don't refuse the conventions, they don't withdraw from, they don't denounce the convention, but they keep them formal. So they ratify, but as there's no sanction, there's no real existence. They don't give real existence to these conventions. They let them formal, like a box, but an empty box. So there's they don't use it really, and they don't use it to protect. And as I mentioned it, but it was too quick, but that there's not very much space for individuals in the international sphere. And if we compare to European system, it's not thanks to the state that the level of protection in European in front of the European Court that is done. It's done by individuals. It's done by the victims themselves. But in the international sphere, the victims have very few access to the judge, and so there's less progress, I think, because of that. And here there is a lack of courage from the state to admit this individual recourse. It was the case in the European system. It was not compulsory for a state to accept the recognition of the individual recourse. Nowadays it is. So there's no other possibility for a state to accept, to be part of the Council of Europe, than to accept this individual recourse. I think that could be a good solution in international system to make sure that people, but of course there's a lot of potential victims. So it would mean a lot of money transferred to the international judge in order to make sure that they would have this the sufficient money to judge. Perhaps also ex-colonist countries, it's better to recognize it, because to recognize that we had nothing to do there, and we did a lot of exploiting people and resources, and it would be, according to me, it would be better to recognize it in order to say, okay, we did that was not a good idea. Now, okay, if we stay on this, then we can't do anything together. We could also do something together, not hiding. The problem, I think, it's all these sides, both sides are hiding a secondary aim. The aim is not to solve problems. The aim is the power, is the manipulating the other and not respecting the other. So we play not a fair play, let's say. It's not fair play. We don't they say something but they do something else. So how to solve this question? Perhaps the recognition of the individual recourse could help, even if we can see that in Turkey and in Russia it's not the solution, even if they are part of the Council of Europe. I see that it's more than 8 o'clock, so but it's still to think and to find a solution. It's urgent and but difficult.
That's absolutely right. Thank you. I've got a message in the chat here which points out quite correctly that it's also about question of speed. I mean, taking into account the European integration and saying that with 27 countries nowadays, it's much more difficult than with 6 countries that we had at the beginning. So that's a very pertinent statement. Is there anything else you would like to add, you would like to ask? Addressing the students now. Anyone else would like to make a statement? ask a question. Well, no, well then, Marion, thank you very much.
So sorry for the technical problems.
No, it went perfectly well. The only thing is that, unfortunately, very unfortunately, we were not able to see you, but
No.
the lecture itself was perfect. So no problems with that. Well, thank you very much, and thank you all for being here and for being with us. I think since that's the last of the lecture series for this semester, that it worked out quite well, and actually we should think about doing something comparable or something entirely, well, something completely different, what we would say next semester.